Now we will read Article 20, which comes under right to freedom, and right to freedom covers Article 19 to Article 22. So we'll start. Now we will read Article 20. Now Article 20 is available both to citizen as well as to foreigner. We'll read three aspects of Article 20, and let's start with the first aspect, that is no ex post facto law. Now let's understand this aspect of no ex post facto law with an example. Suppose there is a person and this person is a teacher. That means his or her profession is teaching, and he was teaching up to yesterday. Let's assume this. Now let's assume, now this is totally a hypothetical situation. Okay, now today let's assume Parliament passes a law which criminalizes teaching. So now whoever is going to teach anyone, he or she will do a crime. That means teaching now is a criminal act. That means no one can teach, and if someone teach, then he or she will be booked. Now, so there is a person who was teaching up to yesterday. Now today, if the Parliament passes a law which criminalizes teaching, now let's assume now police comes and arrests this person. Now let me tell you, police cannot do so, because when this person was teaching, that means this person was teaching up to yesterday, and now this person is not teaching today. So when this person was teaching yesterday, that time teaching was not a criminal act. But now today the Parliament is passing the law that teaching is a criminal act, and today this person is not teaching, but yesterday this person was teaching, and at that time teaching was not a criminal act. So now when today the law is passed and teaching is made a criminal act, and hence police is accusing this person and arresting this person, so police cannot do so, because in India we follow no ex post facto law. That means whenever there is a criminal law that is passed, that cannot be given a retrospective effect. That means this criminal law cannot come into force from back date. And now let's assume after today, when this law is passed that teaching is a criminal act, now let's assume tomorrow someone started teaching. Then this person who is teaching, then he can be booked and put behind bars, because now this person is violating a law. But when this person was teaching, that time this act was not a criminal act. That means this person, when teaching to his or her student, that time he or she was not committing a crime. And that is why when today the law is passed that teaching is a criminal act, by this law the person who was teaching yesterday cannot be booked. That means the criminal act cannot be given a retrospective effect. That means criminal law cannot come into force from a back date. Now let's understand another aspect of no ex post facto law. Now let's assume there is a person, and this person commits murder. Now let's assume hypothetically in India, that for murder in India the maximum punishment is 7 years. So when this person committed murder, this person was booked, and for that he was given 7 years imprisonment. Now when this person was committing this act, let's assume this person committed this murder yesterday, and up to yesterday the law in India was that if this person is committing murder, then this person can be put behind bars for maximum 7 years. Now suppose today this law is amended, or a new law comes, and it says that for murder there will be maximum 9 years imprisonment. Okay, so when this person committed murder, that time for murder he can be put behind bars for a maximum period of 7 years, and he committed this yesterday. But now let's assume today the law has been amended and now it says that for a murder maximum punishment is 9 years. Now this person cannot be given 9 years imprisonment because when this person committed murder, that time law was different. That means a criminal act cannot be given a retrospective effect. But this is not applicable for a civil law. That means a civil law can be given a retrospective effect. That means civil law can come into force from a bad date. So this provision of no ex post facto law under Article 20 is applicable to criminal law only. Now we will read another aspect of Article 20, that is no double jeopardy. So what is this no double jeopardy? It is saying no person shall be prosecuted and punished for the same offense more than once. That means the offense is, so for the same offense someone cannot be punished for more than one. This is not allowed. For example, let's understand this with example. Suppose there is a person and this person has committed murder, and for that murder judiciary has given him or her, let's assume, 7-year imprisonment. Now when this 7-year imprisonment is finished, then this person comes out of jail and let's assume police again arrest this person, produced before the court. Now court is again giving a verdict that you are given 7-year imprisonment for the murder you have committed 7 years back. Now let me tell you, judiciary cannot do this because in India, under Article 20 we follow no double jeopardy. That means the offense was same, that is the murder, and for that this person was given imprisonment of 7 years. So for one offense, one punishment, but for the same offense this person cannot be given twice punishment. This person will be punished for the murder only once by the judiciary. This is no double jeopardy. That means no person shall be punished, no person shall be prosecuted and punished for the same offense more than once. Now we will read another aspect of Article 20, that is no self-incrimination. And what is this saying? No self-incrimination. That means no person accused of any offense. Suppose there is a person and who is accused of any offense, that person will not be compelled to be a witness against himself. That means that person cannot be compelled, that person cannot be forced to be a witness against himself. That is no self-incrimination. And let me tell you, Supreme Court has held that involuntary admission of some scientific test, for example narcoanalysis, for example polygraph. So involuntary admission of this kind of scientific test, narcoanalysis, polygraph, is prohibited under this provision of Article 20. So involuntary admission of narcoanalysis, polygraph, this kind of scientific test violate this provision of no self-incrimination, Article 20. That is why involuntary admission of this kind of test is not allowed. Now we will read Article 21, which talks about protection of life and personal liberty. And this right under Article 21 is available to citizen as well as to non-citizen as well. And Article 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. That means Article 21 is not absolute. That means state can deprive you of your life and personal liberty under a law. That means no person shall be deprived of his life or personal liberty. When we are saying no person shall be deprived of his life or personal liberty, there is a provision by which your protection of life and personal liberty can be snatched. And what is that protection available with the state? That is procedure established by law. That means when Article 21 is saying that no person shall be deprived of his life or personal liberty, there is a clause along with this. And what is that? it is saying except according to procedure established by law. Now let's understand this with an example. Now let's assume there is a person, and this person's right to life and personal liberty is being snatched by state, and this person is produced before judiciary. Now judiciary will ask the question to state, when you are depriving this person of his right to life and personal liberty under Article 21, are you following procedure established by law? If you are following procedure established by law, then it is okay, then you can deprive this person of his right under Article 21. And what is this procedure established by law? That means the judiciary will ask the state, when you are snatching this person's right under Article 21, why you are snatching? Is there a valid law? So is there a valid law? So if the state says that yes, there is a valid law under which this person's right to life and personal liberty has been snatched, then judiciary will ask another question. And what is that question? And judiciary will ask the state another question, and that is, the procedures that are mentioned under that law, whether that procedures have been followed by the state strictly or not. If the judiciary is satisfied with these two things, then the judiciary will say, okay, the state can deprive this person the right under Article 21. That means when it is saying, the Article 21 is saying, except by procedure established by law, that means this person's personal liberty and right to life can be snatched by a valid law. That means there has to be a law, there has to be a valid law by which this person's personal liberty can be snatched, and in that law there are some procedures mentioned. So while snatching this person's Article 21, that procedures have to be strictly followed. If these two are followed by the state, then state can deprive this person his or her right to life and personal liberty under Article 21. But in 1978, after Menoka Gandhi case, the situation has changed. Now in India, along with procedure established by law, we follow due process of law. And what is the meaning? That means now the judiciary will ask another question, will see another thing. And what is that thing? Whether the law under which this person's Article 21 has been snatched, whether this law is reasonable or not. That means earlier judiciary was asking, is there a valid law under which this person's Article 21 has been snatched? If the answer is yes, then the judiciary was asking, there are some procedures mentioned in that law, whether while depriving this person of his Article 21, whether that procedure mentioned in the law has been strictly followed or not. If the answer is yes, then the judiciary was saying the state can snatch this person's right to life and personal liberty. But now, after Menoka Gandhi case 1978, Supreme Court has said that now the judiciary will see another thing. And what is that another thing? That is, now judiciary will go into the reasonableness of the law under which this person's Article 21 has been snatched. So now the judiciary will see whether there is a valid law or not, whether the procedures are followed or not, and whether that law is reasonable or not. That is, now we follow due process of law. Now over a period of years, Supreme Court has interpreted this Article 21 in such a way that under 21 now we have many other rights. For example, Article 21 covers right to life with human dignity, then right to privacy, then right to health, then right to travel abroad. And you know already that right to travel within India is covered under Article 19. And this is the right to travel abroad is covered under Article 21. And there are some others right under Article 21, for example, right to livelihood, right to decent environment, and right against solitary confinement. So there are many rights which are covered under Article 21. So this is Article 21. Now we'll read Article 21A. And Article 21 capital A talks about right to education. So Article 21 capital A is saying right to education. That means it is saying that the state shall provide free and compulsory education to all the children who are in the age group of 6 to 14. And you have to understand, only elementary education is a fundamental right under Article 21 capital A, and not the higher education, not the higher professional education. It is only the elementary education that is a fundamental right under Article 21 capital A. That means the state shall provide free and compulsory education to all the children who are in the age group of 6 to 14. And let me tell you, this provision was not originally present in the Indian Constitution. This was added by 86th Constitutional Amendment Act of 2002. And in this purpose, the Parliament has passed Right of Children to Free and Compulsory Education. In 2009, the Parliament has passed this Act of Right of Children to Free and Compulsory Education. Now we'll read Article 22, which talks about protection against arrest and detention in certain cases. Now let's assume there is a person, and this person is arrested or this person is detained. Then for this person, some fundamental rights are provided under Article 22 of Indian Constitution. And Article 22 is not available. It is not available to the enemy aliens. That means Article 22 is not available to the person of a particular country with whom India currently is at war. Now suppose this person is arrested by the police. So when the police will arrest this person, then the police should let this person know about the ground of arrest. That means why the police is arresting the person, on what ground the police is arresting this person, the police should let it know to this person. That means if you are arrested, then on what grounds you are arrested, you should be told by the police. And this right you have under Article 22. And then not only the grounds, but you also have a right to consult and defended by your lawyer. This is also another right under Article 22 that is provided to you. And when a person is arrested, he should be produced before the nearest magistrate within 24 hours of your arrest, and this is excluding the journey time. That means excluding the journey time, within 24 hours of your arrest, you should be produced before the nearest magistrate. So when there is a person who is arrested, that person, when the police is arresting this person, the police should tell the ground, on what ground the police is arresting this person. So police should let this person know about the ground, and this person should be provided with a lawyer. This person should be produced before the nearest magistrate within 24 hours of his arrest, and this is excluding the journey time. And another right is that this person should be released after 24 hours unless the magistrate authorizes further detention. So unless the magistrate authorizes further detention, this person after 24 hours should be released. These are the protection available under Article 22. Now let's assume there is a person who is detained under a preventive detention law. So let's assume this person is booked under a preventive detention law. So this person is detained under a preventive detention law. Now under Article 22, this person's detention cannot exceed 3 months. But there is an exception. And what is that exception? There has to be an advisory board, and if that advisory board gives a report, and that report says that the detention should be greater than 3 months, and this advisory board is providing sufficient cause, then the detention can be more than 3 months. Otherwise, the detention of this person cannot exceed 3 months. but by the report of advisory board, the person's detention can be more than 3 months as well. Then another right provided under Article 22 to this person is that the ground of detention should be communicated to this person. This is another right under Article 22 provided to this person. And another right is that the person who is detained should be afforded an opportunity to make a representation against the detention order. So a person's detention cannot exceed 3 months unless advisory board permits it. The ground of detention should be communicated to this person, and the person who is detained should be afforded an opportunity to make a representation against the detention order. This is Article 22 for you.